Hello everyone. Today we are going to discuss the topic Extraordinary General Meeting from the chapter Company Meeting. We all know every company used to hold annual general meetings once in every calendar year for the purpose of discussing company's activities with its members and to make important decisions. But sometimes companies may hold meetings in addition to the annual general meetings to discuss and decide urgent matters of the company. Such meetings are called extraordinary general meetings. As per Section 100 of Companies Act 2013, all general meetings of a company other than annual general meeting are called extraordinary general meeting. Extraordinary general meeting is therefore a general meeting which is held between two annual general meetings. Extraordinary general meeting is called to discuss any particular matter of urgent importance to the company. They are convened when it's found necessary to transact certain business which cannot be conveniently be postponed to the next annual general meeting. So, extraordinary general meeting can be defined as a meeting which is not an annual general meeting and it has conducted between two annual general meetings. So we can say that all general meetings except annual general meeting is called extraordinary general meeting. Extraordinary general meetings is usually held in the case of any situation of crisis or when some urgent issues about the company arises, which has to be discussed with the senior executives and the board, and it cannot be delayed until the next annual general meeting. An extraordinary meeting can be called by the directors or by the directors on request of shareholders, by the requisition of shareholders, or by the tribunal. In the first case, that is extraordinary meetings by the directors, Regulation 43 of Table F provides that the directors may, whenever they deem fit, convene an extraordinary general meeting. The board has to pass a resolution to that effect. It says that as per the Regulation 43 of Table F, the directors of the company are eligible to conduct an extraordinary general meeting whenever they find it essential. It means they have the complete right to call for a meeting whenever they feel it's necessary to conduct a meeting. An extraordinary meeting may be called by the directors on the request of the shareholders also. It means the members can also compel the directors to call an extraordinary meeting by making a requisition. Such a requisition must be signed by all members by the members holding not less than 1/10 of the total paid up capital of the company that carry voting rights, and in case the company has no share capital, the requisition must be signed by the members holding not less than 1/10 of the total voting power of all members. The requisition made should specify the issue for which the meeting is called, and it must be deposited at the company's registered office. The third case says that the shareholders can also call for an extraordinary meeting if the board fails to do so. That is, in case the board fails to call for an extraordinary general meeting on a day not later than 45 days from the date of receipt of a valid requisition, within 21 days from the date of receipt of such requisition, the requisitionist may themselves proceed to call a meeting. That means the shareholders can proceed to call for the meeting. They can also claim necessary expenses from the company, but the meeting must be called before the expiry of 3 months from the date of deposit of the requisition. As for the last case, it says that an extraordinary meeting can be called by the tribunal also. A tribunal is like a court established to settle certain types of disputes. So here it says that in case it's unfeasible to convene an extraordinary meeting, the tribunal may call to such meeting either on its own initiative or on the application of any director or any member of the company who has voting right. In this case, one member of the company present in person or by proxy, proxy means representative, shall be regarded to set up a meeting. So these are the ways of calling for an extraordinary meeting. It can be called by the directors or by the directors on request of the shareholders, by the requisition of shareholders, or by the tribunal. Next, let's see what is a notice of the meeting. It says that the board has to call extraordinary general meeting by giving a 21 days notice to all the members who are entitled to attend the meeting. The notice shall specify the place, date, day, and the hour of meeting, and also a detailed statement of the business to be transacted in the meeting. It should be noted that only special business to be transacted in an extraordinary general meeting. It means the business which are ordinary in nature cannot be transacted in an extraordinary general meeting. It has to be transacted in the annual general meeting. Next, let's see the role of a company secretary in respect to the extraordinary general meeting. There are various duties of a company secretary that are required to be performed on holding an extraordinary general meeting. They are if the company may be received a letter of requisition from the members for convening the meeting immediately, the secretary must advise the board on the urgency of the meeting. It says that once the requisition for the extraordinary general meeting is received from the shareholders or the members of the company, it is the responsibility of the secretary to inform the board about the urgency of the meeting. Second one, a board meeting is to be convened in consultation with the chairman to consider the question of holding the meeting. It says that a board meeting will be held with the chairman to discuss the importance of the issue for which the extraordinary general meeting is to be conducted. Third one, if the board approves the meeting after considering the question of holding the meeting, the secretary has to assist the board in preparing the draft resolution and the explanatory statement. Next, the secretary has to draft the notice for calling the meeting and then he should make arrangements for getting it printed. Fifth one, he should dispatch the notices along with the explanatory statements, proxy forms, etc. to the registered address for each member well in advance. Sixth one, he should prepare the agenda of the meeting in consultation with the chairman. Next, he has to prepare a list of proxies and make necessary arrangements for taking part. Eighth one, at commencement of the meeting, the company secretary has to ascertain the quorum. Quorum is the minimum number of members of the company that must be present at the meeting to make the proceedings of that meeting valid. Next, when the chairman requires, the company secretary has to supply the required materials and documents. 10th, the secretary has to take down notes of the proceedings of the meeting. And at last, after the meeting, the secretary has to prepare the minutes and get them approved by the chairman in the next board meeting. So these are the duties of a company secretary in connection with the extraordinary general meeting. Thank you.